Hello, everyone. My name is Ariella Wagner. I am the founder of SunRay Construction Solutions, a national notice to owner service with an incredible online platform to help subcontractors and suppliers throughout the United States of America secure their lien and bond claim rights. Today, we have a fabulous webinar conducted by a brilliant construction attorney, Michael Weiner from Louisiana. And today's webinar is going to discuss the new lien law changes you don't want to miss in Louisiana. So without further ado, I will introduce Michael Weiner.
Thank you, Ariella. I want to thank everybody who joined us this morning to learn about the Louisiana Private Works Act, at least the changes to the law. Excuse me. Before we begin, though, if you have any questions, you can put them in the chat box and we will address the questions at the end. I do want to remind everybody, though, please don't include names or company names. Just the general questions would be great. We had some changes to the Louisiana Private Works Act during this past legislation. I do want to mention, though, however, while Louisiana also has a Public Works Act, we're not going to address that today. We're also not going to do an overview of the law. We're only going to address the more significant changes in the law. So I'm assuming you all have a general understanding of Louisiana's Private Works Act. Before we get to the changes, I do want to mention that fortunately there were no substantive changes to who can assert a privilege for performing work for the owner. There are different claims, different privileges for those who perform work directly with the owner and those who perform work for a contractor. There were no changes to those who perform work for the owner. In addition, there were no substantive changes for those who perform work for a contractor. And when I say no substantive changes, I'm just talking about who can assert a claim. It does clarify the new law that a contractor who pays a subcontractor's employees is subrogated to the claims of those employees against their employer. However, the act was clear that even if you as a contractor pay a subcontractor's employees, it cannot serve to save your lien rights because you cannot take a subcontractor's lien rights against it under the Private Works Act. With respect to what is secured by a claim and a privilege, the act clarified that your claims do not secure attorney's fees. In Louisiana, you're entitled to attorney's fees by statute or contract. If you have a contract that allows you to collect attorney's fees, unfortunately, that aspect of your claim is not preserved under the Private Works Act. All that your claim under the Private Works Act would be is for basically the balance of that you're owed for the work that was performed, which is supported by a privilege. The Act also clarified that if you have consultants or subconsultants that work within a juridical entity, in other words, there's an LLC or a corporation, then those consultants and subconsultants do not personally have the claim. It's only on behalf of the company. Certain claimants under the Private Works Act have additional notice requirements, and one of those are lessors of movables. That means if you lease equipment for a job site. The good news is that the changes relaxed prior what I think were pretty onerous notice requirements on lessors of movables. Under the prior act, or before the changes, the lessor had to give notice signed by both the lessor and the lessee, the person to whom they leased the equipment, and they had to give the notice to the owner and the contractor within 10 days after the movables were first placed on site. Normally, people would use a copy of the agreement. And if you didn't give that notice within 10 days, then you had no right to file a claim, or you didn't have a privilege in the lessor's favor under the Act. 10 days, as you can imagine, is a pretty short time frame. So no matter how long you were on the job, you could be on a job for a year or two, your equipment at least, but you would have no right. Fortunately, they changed the law, and now the lessor of movables has to still give notice, and you have to give notice to the owner and the contractor. Well, you have to give it to the owner if a notice of contract was filed, because that would give you information from the owner if they're not a party to the lease, and the contractor, unless they're a party to the lease. But if the notice is given later than 30 days, then you do not lose your entire right to claim and privilege. All you lose is the rents that accrued prior to the notice. But if you give the notice within the 30 days, then you have preserved your claim and your rights for all rentals. So give your notice within 30 days to preserve your entirety of your claim. But the good news is, if you fail, you could still give notice later, but it'll only preserve your rights for rentals due after the notice is given. What does the notice have to contain? Just the name and address of the lessor who is renting the equipment, and a general description of the movables, just a general description. Now, the owner and or the contractor has the right within to request that you provide a more specific example or listing or description of the equipment that's being leased. And if you get a request, then you have 15 days to provide that information. Interestingly, and this is again a new law, so I'm not sure how this is going to be interpreted by the courts, what the statute says is that if you don't give a timely and accurate response to the request, then you lose your claim and privilege, but only to the extent of any damages suffered by the person making the request as a result of the failure or inaccuracy. I'm not exactly sure what that means, and we're going to have to leave that up to the courts to determine. But if you do respond within 15 days and give a full description of the equipment that's being leased, then you have preserved your rights and you don't have to worry about it. Oh, and it also bears noting that you don't have to respond to this request unless you've previously given notice and to preserve your claim. But obviously, we hope that everybody is going to give that notice, because without that notice, you have no claim. Now, seller of movables, basically people who supply material to a project, the law now clarified that if a seller of movables does not provide required notice and they have an additional notice requirement, then the seller loses its claim against the owner and contractor and its privilege in the property. So if you don't, as a supplier, if you don't provide the required notice, nothing. Unlike the lessor, you can't reserve your claim for a certain amount. You have to give notice. Now, the good news, though, for the seller of movables is the notice is due no later than 75 days after the last day of the calendar month in which the supplies were delivered. In other words, you don't have to give notice ahead of time. You can supply the material, and if you don't get paid, then within 75 days of the last day of the month that the material was supplied, you have to give notice. So every month, I would suggest that you haven't been paid for material, you have to give notice for that month. There used to be cases that said, no, you just had to give it at the end, but there's cases now that disagree with that. And of course, this is a new law, but I would suggest that anytime you don't get paid within 75 days of the last day of the month that you delivered it, give notice of that unpaid amount. And that notice has to include the name and address of the seller, the name and address of the subcontractor, a description of the material that was supplied, and a statement of the unpaid balance, basically what's owed to the seller for the supplies. Under the changes now, if you perform preliminary site work for the building contractor, you now have the same deadline to file a statement of claim as other persons performing work on the building. It used to be a different time period, but now it doesn't matter. We're going to get into what that time period is a little bit later. Now, a notice of contract, what is that? Well, that is a notice of the contract, exactly what it sounds, and it's supposed to be filed by the owner or the contractor. And now the notice must contain a complete property description. This is the obligation of the owner or the general contractor, and other lower tier contractors do not have this obligation. What is a complete property description? Well, now they're changed the law to say any description that if contained in a mortgage of the property would be sufficient for the mortgage to be effective. Okay, what does that mean? Basically, do not use just the address. You have to have more than that. You have to have more of a legal property description that talks about sections. At best yet would be meets and bounds, but you can get that through an abstract, or hopefully it will be attached to the notice of contract, which will be filed, and then you will be able to use that. In addition, it increased from 25,000 to 100,000, the threshold that required a notice of contract to be filed. Now, what that means is for projects that are worth over $100,000, a notice of contract has to be filed, and as we'll discuss later, if it's not filed under those conditions, there are some effects more drastically to the general contractor, but also to the subcontractor. Now, I don't know how many of you listening are general contractors, but this is a very important change. Under the old law, there were cases that held if a general contractor failed to comply with its filing requirements, meaning that it failed to file a notice of contract. And let me back up a little bit. I know I said I wasn't going to go do an overview, but just for the purposes of understanding this point, a general contractor must timely file a notice of contract to preserve its ability to file liens. The failure of the general contractor, or the owner in fact, to do this does not affect the right of lower tier subcontractors to file liens, but it does affect the timing. But under the old cases, if the general contractor did not file the notice of contract, they held that the general contractor could nonetheless file a lien as an ordinary contractor for work itself performed. Well, now the law has changed that and has basically held that, at least under the new law, if the general contractor fails to file a timely notice of contract for projects that exceed $100,000, that general contractor has lost its lien rights. Now, as to the bond, if the work is estimated to exceed $100,000, then a bond must be issued by a surety company licensed to do business in Louisiana, and the bond must be equal to the price of the work. It used to be a tiered amount of when how much the bond was to be required. Now, if a bond is not filed, then all that does is change the rights of the owner. The owner, if a bond is filed, has certain rights to get claims against it dismissed and claims against its property. It loses that right if a bond is not required. That's all the failure of a bond does. Liability of a surety. Basically, you don't have to deliver a statement of claim or privilege or a copy of it to the surety 30 days before filing suit. That's no longer a requirement, but it does provide, the new law does provide that you shouldn't file suit within the lien filing period because then that would be premature. So wait till after the lien filing deadline and then file your suit to enforce your lien. Now, to preserve your claim and privilege, the new law clarifies that you can file your statement of claim anytime before the deadline. You don't have to wait for the commencement of the filing period. There are some cases out there, mostly for the Public Works Act, but there was concern by the bar that they may be interpreted to apply to the Private Works Act. But now it doesn't matter under the new law. Anytime before the filing deadline, after, of course, your claim has matured, then you can file your statement of claim. As to the filing deadline, if a notice of contract was filed, and we talked a little bit about that earlier, and a notice of termination or notice of substantial completion is filed, then a contractor still has 30 days to file its statement of claim. That's not a long time, but you do have 30 days. So when your project is getting close to completion, you may want to start paying attention to those issues. Now, this is important. The law did change one deadline, and it now provides that contractors have an outside deadline of 6 months if a notice of contract was filed, but no notice of termination or substantial completion is filed. Under the old law, a filing of a notice of termination or substantial completion was required to even begin the lien period date, the filing requirement. So now under the new law, if there's no notice of termination, but there is a notice of contract, then you've got a deadline of 6 months to file a lien. The general contractor has 7 months if a notice of contract is filed, but no notice of termination. Now, again, if you are a general contractor, you can force the owner to file a notice of termination if the project is substantially complete or abandoned. And if the owner refuses, then you can go to court and obtain a judgment and file that. And again, what does that effect that has? It reduces the amount of time that a subcontractor or lower tier contractor has to file its statement of claim. Now, the statement of claim, when filed, now it's supposed to identify the owner who is liable for the claim. Not all owners of the immovable property are liable, just those who contracted for the work. And it's, and if the owner is not of record, in other words, it could be a lessee that does not have a recorded lease, and you can't find that information, and you don't know who the actual owner is who requested the work, then you can list whoever owner is listed in the public records, and that is sufficient. You could still request the notice of the owner of substantial completion or abandonment of the work. In other words, you can say, look, owner, I want you to tell me when the work is complete so I know when to file my statement or claim. You have to make this request before the filing of a notice of termination, because that's obviously triggers one of the events that triggers the start of the deadline to file your claim, or you have to do it before the substantial completion or abandonment of the work. In fact, nothing that has been filed. You still have to do it if the project has been substantially complete, and it's hard to tell that, but you need to do it earlier. Now, if you request it from the owner and the owner does not give you this information, and you don't file your statement of claim timely, then your claim against the owner is not extinguished. You still have your claim against the owner, but you lose your privilege in the property, and you still have to file suit within a year. So that's a bit of a change. And as I said, the privilege is extinguished if you don't file the statement of claim. So you do have a claim against the owner, you don't have a claim against the property. In other words, your claim is not supported by the value of the property, which may or may not be a problem depending on if the owner sells the property in the interim, or if the owner has no assets other than it could be a single project owner, which means that without a claim against the property, the claim against the owner really doesn't help. Oh, and also that the requirement that an unpaid seller of movables, again, that's somebody who provides material for residential work, deliver the non-payment to the owner at least 10 days before. That's no longer in effect. And they used to have a 7-day period, but that's also gone. So basically they're under the same rules as everybody else. The place of filing, basically you just have to file where the immovable property is located. And now here's a little bit of a change. The statement of claim or privilege has to have a description of the immovable property. And you can satisfy that by referring back to the notice of contract. But if the notice of contract does not have a reasonable identification of the property, then the statement is not sufficient. So that is not valid for all purposes. However, it will preserve the claimant's rights against the owner and the contractor, but you lose your privilege in the property and against third parties who subsequently purchase it. So it's better to put your own property description into the statement of claim rather than just referring to the notice of contract. If you name the wrong owner, in other words, you name the owner of record who didn't request the work, they can have the claims against them dismissed. That's fine because it does not affect your right against the true owner who is required to pay the claim. Another important point, though, that has changed is that it now clarifies that the recorder of mortgages or the clerk of court is required to cancel your inscription, basically your statement of claim and your privilege, if you fail to file a timely notice of pendency of action. What is that? Okay, well, that's what's called a notice of lis pendens. You have to file suit within a year after filing your statement of claim. And if you don't also file a notice of that suit in the mortgage records, then you lose your privilege. And under the new law, then your statement is canceled per se. They don't require anything further than the lack of that. If the owner can say, look, he filed suit, sure, but didn't file the notice of lis pendens, you've lost your privilege in the property. They can now sell that property out from underneath you. You can now deliver notice by electronic means, by emails, if the person consents to that method of delivery. So I would try to get that in your contract, and I think we can argue over time if they've accepted notices that way, because email is certainly much easier than by mail or certified mail or registered mail. You do need electronic confirmation of receipt, but if you get that, then it will be considered served and notice provided. For those who provide work on residential property, there is a notice to the owner that's required, and they've changed that. It's too much to go into now, and there's an example of it in the statute of what you need to provide. Okay, I know we're a little bit over time, but almost finished. The effective dates, this is important. Generally, the law, the new deadlines, all the changes are effective January 1st, 2020, and it will apply to work begun on or after that date, unless there was a notice of contract filed before January 1st, 2020. Now, if a notice of termination is filed before January 1st, 2020, then the filing deadlines are not changed. In other words, if a notice of contract was filed and a notice of termination is filed before January of next year, then we're under the current statute. We're not under any of the changes. Now, if no notice of termination was filed before January 1st, 2020, and the work is substantially completed or abandoned after that date, then the new deadlines apply, even though the work was started before January 1st, 2020. The amendments, which address the rankings of their privilege, they apply retroactively to all works. And the issues that we talked about canceling inscriptions of claims and the notice of lis pendens, that also applies retroactively. And I thank you all. That is my presentation. And I know that Ariel's got a couple of things she would like to speak about next.
Okay, great. Thank you so much, Michael. So we'll go on to the next slide. So many of you know your customers of SunRay, but you can use our online portal, and all the forms that he's discussing, they're online. They're easy to select in our online system. So you can go online if it's residential, commercial. Those are your private projects. If it's a public project, there's different statutory forms for that. Those are on our online system, so you don't have to worry about that. The next slide. So all it takes is approximately 60 seconds, and that's all it is, 60 seconds to enter in a request. Your job address, who you have a contract with. If you have a contract with the subcontractor, of course, we want to know who the GC is. Only 60 seconds if you have the information in front of you. And the next slide. And this is one of the most important parts of your lien and bond claim rights are your reminders. So the SunRay application assists you by sending you email reminders, and it's also saved in your Outlook or your Google account if you have a Google account. And on the next slide, you could do all of your waivers and releases of liens in our system for free, and you can manage everything online for free. So if you give out 10 partials, it's all stored online so that you could see what you gave to your subs or the general contractor or even the owner of the property. And on the next slide. And that's it. And so far, we do have one question. The question was, when you refer to material supplier, I'm assuming the same rules apply to a labor supplier. We are a staffing agency. So I think that was on one of your slides about 3 minutes ago. So if you can explain that.
Yes, a staffing agency is in a unique situation. The law is unclear about that, and it does not treat labor suppliers exactly the same. Because of your laborers being on site, you may be considered a subcontractor to your contractor. It depends on whether you're providing supervision or so forth. But because this is a new law and changes to the law, until it has been shaken out, then providing that notice could not hurt. It certainly would not affect your rights if you're considered a subcontractor. But because you're providing labor that is actually doing work on the site, I would argue, if you didn't provide the notice, that you're a subcontractor and do not have to provide those rights, those notices.
Okay, great. Thank you. Are there any other questions? So far, there aren't any, but if you think of another question, please go to our next slide. You can certainly, there's one more slide which contains all of our contact information, but we have right now, we have my contact details and of course Michael's contact details. So if in fact you have an additional question that you think of after this where something didn't make any sense, please feel free to email or call us, and we would be happy to assist you. Michael, you did a brilliant job. Thank you so much, and for this great webinar.
Well, thank you, Ariel. I appreciate the opportunity.
Thank you, and I wish everyone a sunny day.